Guys, if you are ready, comment ready in the chat box fast. All right, great. So again, welcome to the day 2 of this IPR workshop organized by Central University of Haryana in association with SkillSlate Foundation Pune. This workshop was specially organized to help you guys learn about the basics of the IPR as well as the copyright processes. And yesterday we have covered all the basic things about the intellectual property rights. And today Jayashree ma'am will be telling about the process on how we can file these IPRs, and she will also be sharing us case studies with us. So I'm sure that you all enjoyed your yesterday's session. In case if anyone of you has missed the yesterday's session, the recordings will be available on YouTube, and the link will be shared to you via the email. Also, we have shared the link yesterday as well. Today's session will also be recorded for your convenience, but we request you that it is better if you attend these sessions live, so you can ask the questions while in the live session directly to the trainer towards the end of the program. So again, I welcome you all the participants who have joined us on the Zoom as well as the YouTube. Welcome. Please take a moment if you want to get your pen and your book so that you can take notes. All right. The recordings will be available, but it is better if you take notes so you can have easy access to them whenever required. So thank you so much again. Myself, Ameya Agrawal, I'm the founder of SkillSlate Foundation, and again, I welcome you all for this session. Sunita ma'am, if you would like to say a few words to begin our today's session, and then we can move ahead and hand over our session to our esteemed speaker, Jayashree ma'am. Sunita ma'am. Hello. Sunita ma'am, am I audible to you?
Yeah, myself.
Yes, ma'am. If you would like to have some opening remarks, then we can hand over the session to our.
The session was very wonderful. Definitely, I think more people have joined today. So instead of wasting any of the time, important time which needs to be given to the participant, I just request Jayashree ma'am to start with the session. So, Ameya sir?
Thank you so much, ma'am. Jayashree ma'am, the session is yours and the participants are waiting. Thank you so much, Jayashree ma'am.
Yes.
Yes, ma'am, please unmute yourself once. We have muted all the participants. To
Yes, sir. Just give me a second. Just a minute, huh? Just a minute. Okay. So, a very good morning to all of you. And today we are having our second day of this national workshop, and I will be now happy to share the further knowledge with you all. And I'm hoping that yesterday's sessions, both the sessions were useful to all the participants, and yesterday also there were many questions asked by the participants. So a few questions actually because of the time constraint I could not answer it. So today I will answer those questions also. And today I have kept my session very brief so that we will have the time for the question answers. So today also first session I will talk about the copyright, then its importance, then Copyright Act, and then we will discuss few cases of IP. So not only related to copyright, but we can discuss the cases related with the patent also. As per the suggestion of the few participants yesterday, I have included a few cases in the session. And the second session is focused on the importance of IPR or role of IPR in academics, research, and also career opportunities in IPR. Because yesterday Ameya sir has given the feedback that 50% of the participants are faculty members and 50% are students. So I have divided my session in both the ways, so that students will also get the benefit of it, and also faculty members will understand the role of IPR in the academics and also in research. So I have divided this session in this part. The last session will be for the faculty members. First half is for the faculty member and the latter part is for the students. So just give me a second. I will share my screen. Okay, screen is visible to all of you?
Yes, ma'am.
Okay, okay. So first session is related or based on the copyright, its importance and challenges. So yesterday we actually talked about or discussed rather about the types of the IPR, and the second session was on the patents. So in detail, I have discussed about the patent and the Patent Act 1970, how to file the patent application, what is the format of the patent application, and the other things that we have discussed yesterday. So today I will discuss on the copyright importance and challenges, because the copyright is also one of the important type of IP, and many things actually may be known to us. So that's why I have focused this session on the copyright. Just a minute. Yeah. So this is the presentation outline. So first is definition of the copyright, then copyright and related rights, then its registration process. And as I said, a few copyright cases and other cases I will discuss, and then concluding remarks of the session. So what is basically this copyright? Now, roughly we know that copyright is nothing but it's a right to copy. So whatever content actually creator or author is writing, or whatever the artistic work the artist is creating. So by default, the copyright of that material goes to that creator or the artist or the author. But if you want to file some infringement case against anybody who have suppose used your work, then in that case, the work should be registered properly through this Copyright Act in the Copyright Office, Indian Copyright Office. So otherwise it is very important to know that whatever we are creating, whatever we are writing, the rights automatically by default goes to the author or creator. So it is one of the important element of the intellectual property. Copyright protects the right of the creators for his or her own literary or artistic work. And it is basically right to copy. So we will see in detail, according to the Indian Copyright Act 1957, what can be copyrighted or what can be protected under this act, and what is not allowed to protect under this act. So according to the Indian Copyright Act 1957, literally dramatic, musical, artistic work, cinematographic films, sound recordings, all these things can be copyrighted. Now, what can be protected? So all these things mentioned on the PPT. So computer software, then drawings, then maps, then photograph, films, then sculpture, sound recordings, TV and radio broadcasts, books, novels, all these things, you can have the copyright of all these things. So actually, what is the exact definition of this according to the Act? So according to the section 14 of this Copyright Act, Reproducing any work, storing it in electronic form is allowed. Issuing copies of the work which are not in circulation, obviously, because if it is in circulation, you cannot file its copyright. So performing, communicating the work to public, then making cinematographic film or sound recording, and translating and adapting the work. So all this is allowed in the Copyright Act according to the section 14. Then this TRIPS, actually yesterday I have discussed about this TRIPS, trade related aspects of the intellectual property rights. And one of the question I just remember now, that one of the participants asked about this TRIPS, that whether this TRIPS agreement clause are different for the developed countries and developing countries. So I will just answer this question first, and then we will go ahead. So actually that is true. So for the developed countries, if they have signed these TRIPS, then they have to actually consider the IP situation or maybe the research work in the industrial area in the developing countries, and they have to actually inform this body, TRIPS, whatever is the authority. Accordingly, they have to inform them, and then they have to consider the situation of the research or maybe the IP in developing country. They have to consider that, and then they have to go ahead. So that's why the some of the clause under this TRIPS are different for developing countries and for the developed countries. So coming to this point, so this TRIPS, actually it's a right to reproduce the work. So according to the Article 10, it gives the rights to the author. So any software which are or with hardware, that is also allowed, because if you remember, software or maybe the programs, you cannot have the patent of that. You have to go for its copyright. You have to register it for its copyright. Just a minute. Just a minute. Yeah. Yeah. So under artistic work, then painting, drawings, photograph, all these things are allowed. Then reproducing, storing in electronic form, maybe 3D work, 2D work, then its adaptation, then communicating it with the society, then issuing its copy to the public. All these things are allowed according to the law. Then you can make a copies of the film, including photographs. Then you can sell it. You can give on commercial rental also. So licensing is also allowed in this Copyright Act. So all these things according to the law is allowed. So sound recording is also, you can have the sound recording and it's copyright with you. And actually most of the participants in the audience know about this, that all these things can be copyrighted. So what cannot be protected under this act, that is important. So what is not allowed is works which are common and available to public. So as it is the what I can say, it's a common actually rule that whatever is publicly available, that you cannot have rights for that. You cannot have patent of it, or you cannot have the copyright of the work. So this is the common thing for all the IPs. Then ideas, concepts or discoveries is not allowed in the Copyright Act. If you want to have the protection for your idea, concept or discovery, you have to go for patenting. So you have to file its patent application. Ideas and concepts are not allowed in the copyright. Then this is also a very important thing is, and there are many actually cases and fights, rather I can say, because titles, names, and short phrases, slogans, you cannot have the copyright of all these things. And in film industry, you might be knowing that these names, they are using the names of the old film nowadays, and there is a fight between two producers, because titles, names, short phrases, and slogans are not allowed according to the act. Then improvised speech and dance is also not allowed, and the works not fixed in a tangible form, that is also not allowed. So this few things which are not allowed in the according to the Copyright Act, and then there is a what I can say, there are many challenges or issues related with this act, and many experts are already talked about this. They have discussed about this. They have published articles based on this also, and because of this, there are many cases filed in the court, because it is not quite clear according to the act. So I will give you the few example after just finishing the registration process of copyright. So this Copyright Act gives the right of reproduction. It gives the right of communication. So owner of the copyright can have the right of reproducing his work. Then he can communicate to the public by means of any actually communication platform. It may be electronic, it may be physical. So all the rights are with the creator or author. Then right of adoption, then right of translation is also with the author. Then moral rights are also assigned to the individual author, and basically they are related with the economic rights. Then rights in dramatic and artistic work, so this is also given to the creator. Then rights in musical work, rights in sound recording, so all these things, and rights for the computer programs. So this computer programs, I have told you already this, that it comes under the literally work, and that's why this is protected under the Copyright Act and not under the Patent Act. So all these things are can be protected under this Copyright Act 1957. So if anybody wants to suppose file a copyright application, then what will be its registration process? So if you just see the registration process for all the IP is actually similar. So first of all, you have to file the application on the given website. So IP India is the government, ipindia.gov.in is the site for the patent, and copyright.gov.in is the site for the copyright application. You can file the application on this site, or you can form it in the physical form also. The first step is you have to file the application. Then application number will be generated. So as per the yesterday we have seen the filing patent application, so procedure is almost or more or less the same. Then a particular period is given, so 30 days are given for the objection. So if anybody has any objection, they can raise the objection. If there is no objection, then it will go to the scrutinization by the examiner. So examiner will just go through it, will check each and everything, whatever applicant have claimed the copyright of work. So it will go through it, and if there are no again objection, then it will go to the further steps. And then if each and every condition is satisfied, then only the copyright is given to that particular author. So this is the copyright registration process, and again it each and every step has its particular time duration, and fees and all these things you can just go through the website copyright.gov.in, and you can get the each and every information regarding that. So okay, so then copyright application format. So what is in the application of the copyright is the name of the applicant, address of the applicant, then name of the author or creator, then its address, nationality, type of work, title of work, each and everything should be mentioned in the application. So whatever work published before, you have to keep the details of that also, and 2 copies of the work you have to submit along with the application, and signature, contact details, all these things are compulsory actually in this copyright application. So this is the standard format of copyright application. As I said, actually there is no need to to register or to file a copyright application, because once a creator or author have written something, then by default its rights goes to that creator or author. But if anybody has used your work, and if you want to file an infringement case in the court, then you should have the copyright registration. So that C, you must have seen that C for the copyright. So you should have that copyright registration. Then only you can prove in the court that it is your work. So original work belongs to you. But if you don't have to do anything related to this, then by default copyright goes to you. But now again, the another interesting thing is that if you are not interested in, suppose, financial benefits, so some of the people, they are not interested in financial benefits, they just want to remain within the boundaries of the copyright law, and they just want the credit of his work. So in that case, this Creative Commons actually give the license for this. It's actually you can just search on the Google, you will get the information of this Creative Commons, and on this you can just register your work, and then the credit of the work will goes to you. So it is actually having a particular procedure. But if anybody is not interested in the financial benefits, then they can register their work under this Creative Commons. Then similar to the Patent Act, licensing of copyright is also allowed or available according to the act. So in Patent Act also, because in patents also some invention or maybe some idea that is patented, and the rights of that idea is with the creator or inventor. But if that creator or inventor doesn't have a sufficient amount to go for the further step, to go for the production of it, go for the manufacturing of it, then in that case they can assign the licensee, and then give have a written agreement, and then that licensee can go for the manufacturing, and then whatever terms conditions are decided, according to that the creator or inventor can get the financial benefit. So in the similar way, licensing of copyright is allowed according to the act. So copyright owner may assign copyright partially or maybe fully, it depends upon the owner. So again, it is a written agreement, and whatever terms conditions are mentioned in the written agreement, they both have to actually follow, owner also and the licensee also. So this is possible. And once the copyright is given to the author, once you have filed the copyright application, and after fulfilling all the conditions, somebody has raised the hand. So if you have any question, let me just finish this, and then we will have the question. Okay, let me finish some of the part of the session. So duration of the copyright is lifetime of author plus 60 years. Means it is a very, very long duration. So you can say that once the copyright is assigned to the owner, it is with the owner. It is not similar to the patent, because patent duration is just 20 years, and after 20 years, the invention is available publicly. Okay, so that is not the case with the copyright. Then this Copyright Act 1957, and what are the challenges? Because see, if I go discussing the Copyright Act, then it is very, very vast act, and but this is not the scope of the session also. So instead of that, now we have understood that what can be protected under this act, what cannot be protected under this act. So we will see the now challenges of this. So protection under this copyright law in India, we are talking about the Indian Act, Copyright Act 1957. So according to the act, so this is actually the front page of this act, and according to the act, whatever points just now I have mentioned, all these things you can have the copyright with you, with the author. And similarly, yesterday we talked about that if any person wants to file the patent application in foreign countries, then what is the procedures, how to get the patent in foreign countries. So through PCT or applications, the creator or inventor can have the protection for his or her invention in foreign countries. So here, Berne Convention is one of the famous treaty. It is for the copyright. So if any author or creator wants to protect his work in other countries also, then he or she has to file the application through this Berne Convention. Okay, so till suppose date, I think 178 member states are the member of this Berne Convention, but now they are increasing. So it is, I think, around 182 now. So all these countries, they have signed this Berne Convention, and if any person in India, suppose, have filed the copyright application in Indian office, copyright office, and if it is granted, then that work is protected in all the countries who have signed this Berne Convention. So this is the another what I can say, if you want to protect your idea in foreign countries also, then you have to file a application through this Berne Convention. Then some of the challenges, maybe many faculty members have joined the sessions, and they are quite familiar or to all these words also. Plagiarism is one of the word, and what is the meaning of it is that actually others' works or idea without taking creator's permission, or rather without mentioning his reference, is not actually allowed. So whenever we are writing maybe MPhil thesis or PhD thesis, or maybe just a report, project report. So if the students are from the BBA, MBA, then if last year they have to do the project. So in the project report also, if they are taking some reference from the others' work, then they have to mention its reference. So many times people, actually most of the time, they mention its reference, but in some cases, if it is not mentioned, then it's a plagiarism. So creator can get additional profits from other party who has made from his work, and if someone proves that, this is last line which is mentioned in the red, is very, very important. We are going to discuss this fair use in the latter slides. So if suppose the person who have used the particular work and not mention his reference or her reference in the report maybe, then if he proves that it was done unintentionally, then the case can be destroyed. So this is actually the case with all the types of copyright cases, that if the person proves that it was done unintentionally, then that case can be destroyed. So if it is not for the financial benefit also, then you cannot file the infringement case against that. So this is a very, very important point. And again, it's a challenge also, because many times people prove that it was done unintentionally. Then ownership, creator is working in a company. So this actually was the common questions in every session actually, that suppose we are working in a university, we are working in the college, or we are working in the IT company or any other company, and if that person is supposed have done something creative or inventive, then who will file that? So automatically employer owns the copyright, because he is the employee of that company. The owner of that company will get the its copyright, or maybe it is same thing is with the patent also. So if in IT companies or in big companies rather, if they have filed the patent, then it is not with the employee, it is with the company, it is with the employer. So ownership always goes to with the employer. Then copyright related to digital world. Now it's very, very vast, and there are so many copyright cases. So in the last workshop also with Ameya sir, we have actually called one of the very famous lawyer. He was a copyright lawyer, and he was also talking about that there are many, many cases related to the copyright, because as I said, there are many challenges of this act. That's why there are many cases. So it may be related to the digital world, it may be related to the musical world. So issues related to new works such as computer program, database, multimedia works, all these things, the invention in photography resulted in the photographs named as phonograms and cinematographic films or video films. So there are again issues with this. So what are the issues? It is related with the reproduction, then also it is related with the distribution of the work to the public through any digital media. So So basically, what I can say that according to the Act, actually, artistic work in any material form are not covered in the Act. So this may be the challenge of the Act itself. So definition of the cinematograph, film and sound recording, this is mentioned in the Act, but artistic work in any material form, this is not covered in the Act. And then if something is not mentioned in the Act, then there can be many actually questions on that, and then related issues. Now we know that as we are using the Google every day, and in just 1 second we can get any ample of information of anything. So we can get anything on Google. So copies can be made within a few seconds, that we know that, and also that can be distributed within few seconds. So there is actually issue of the privacy, safety of anybody because of this digital environment. So that is the another issue related with the copyright. In academic writing, as we are talking about, some of the faculty members, they have joined, and also students have joined the session. So usually this academic writing is classified in the research writing, maybe research papers, research articles, then thesis, then reports, then you can say book writing, article writing. So all these things comes under the academic writing. But this what is the challenge of this Copyright Act related to the academic writing is that this is the one clause in the act is there, which is known as a fair dealing clause or fair use. It is known as a fair use clause. So what is this fair dealing clause is nothing but it is dealing of any literally dramatic, musical, artistic work. And if that work is used not for any to get any financial benefit, then it is allowed according to the act. Means if you are using the work for your maybe the for purpose of private or personal or research review, then you cannot file infringement case against that. So that is the one of the important clause of the Copyright Act. So Indian statute does not actually tell you the definition for the term of fair dealing. So I will give you one example which was actually recently happened in Pune. So one of the I think I don't remember the name, but the family was very rich and they are having their marriage ceremony in one of the area of the Pune, and it was came into the newspaper actually, and they were just having that ceremony, mehendi and all these things, and they are playing the music for this, they are dancing on that songs, and the company which have the rights of this song, they actually tell that person that you have to give us the 70,000 or something more than that as you are using the copyrighted material in your marriage ceremony. And he actually gave the money amount because he was rich, and then some of the people tell that person that you should inquire about this, and then he filed the police case and all these things. And then on the second or third day came news in this in the newspaper that actually if that music or maybe that songs are the people are using for entertainment purpose and not getting any financial benefit of it, then it is allowed. So they the person got the amount back, and then the inquiry is done. So the main thing according to the act is that, which is under this fair use clause, that if you are using some of the work not for getting some financial benefit, then it is allowed according to the act. So that is the main thing of this Copyright Act. So this is the another actually issue, not issue, but it is allowed according to the act. Just a minute. Okay. So the act not according to the act, the following things are not considered actually. So copyright material available on internet. So now everybody is using the internet, using Google, and we are downloading anything from the Google. We are using it without taking permission of anybody. But if you're doing it for the sole purpose of your study, or maybe for just to understand the concepts and all these things, then it is allowed. If you are not selling the copies of the work, or maybe distributing the copies of the work, then for financial benefit, if you are using it, then it is not allowed. Then teachers, as we are teachers, many teachers are in the audience, so teachers are making use of the material of for their class. Now from last 2 years we are using this online platform for teaching, and we are preparing the PPT and all these things. But if you are just taken some of the work from the other creator or author, then it is allowed, because you are not using that work for any financial benefit. So you are using it for the purpose of your maybe for class teaching, or maybe for your study, then it is allowed. Then backup copies of hard drives, they are not considered in the act. Then delivering any speech in the public, that is also not considered in the act. So all these things are not considered in the act. This act actually was amended in 2012, and they have actually included the provision of the protection of this copyright in the field of digitization, because as the use of this digital media is increasing day by day, they have amended the act in 2012, and they have now provision for the penalties against the infringer, and rights of management information or liability of internet service providers. All these things now they have included in the act. Now I was talking about this fair use of copyright. So this clause is very, very important. I have explained this just a few minutes back. So fair use of copyright, that it permits limited usage so as to maintain the originality of the work. If you are using the work in the field of education, if you are using it for the purpose of research, if you are using it for the private or non-commercial, that what is important, non-commercial, then it is allowed. Then if you are using it for the report of current events or critical review, then it is allowed. So all these things are allowed under the fair use clause of the Copyright Act. Then limits of the copyright protection of the title of creative work. Now, there are actually many cases happened till today, but I have just mentioned one case that in the three or fourth, fifth slides, we have seen that titles, phrases, slogans, they are not allowed. You cannot have copyright of this. So one of the famous example, you can just see that, and it was in the newspaper, in the media also, it was famous. So Bollywood movie Ravan is an example, because you cannot have the copyright of that title. It's a title of the movie, so you cannot have the copyright of that. You can have the copyright of the movie itself, but you cannot have the title of the copyright of the title. So this Ravan was the movie, and then it has used in various products, including toys, stationery. So people have used this title for many purposes actually. Then copyright infringement in the cinematographic film. So there is a conflict decision actually by the Indian court whether the infringing copy in case of this particular cinematographic film has to be exact copy. Means, see, now here again, if you just see, there are many movies, they are, we know that it's a copy of the old movie, or maybe the movie in the other languages, but still, as it's not exact duplication of that, then it is allowed. So whether it refers to another work which fundamentally or essentially materially reassemble the original film, means the idea is taken from the film, and then whatever is the writer of the film, he will just prepare a story around that, what I can say, concept. So this is allowed. So this is the another challenge. Then if the work is converted into the formats which is accessible to the persons with disability, then that is also allowed, because it is not, in that case, it is not the what I can say, copying the work, because you have just converted the work which should be understood by the person with the disability. So this is allowed. Then this is also one of the common questions from the audience, that what about these emojis? So can these emojis, every day we are using lots of emojis on the WhatsApp, so are they copyrighted? So actually it's if you just see, these emojis are nothing but the graphical designs, isn't it? So it's just a design, and based on a particular code, maybe a smiley, maybe sad face, maybe a happy face, like that. There are ample of emojis. Expressions are protected under Copyright Act, but not ideas. Actually, if you want to have the protection for your idea, then you have to go for the patent. Okay, so this emoji is of actually the combination of both, means it is idea also, it is expression also. So this emojis falls in the gray area actually. So what they have done is that Unicode is a non-profit organization, and under this actually organization we can get the free usage of these emojis, and now we are using freely, because WhatsApp and all these things are providing these things freely to us. So this is also another thing. Now we will discuss few IP cases. As I said, there are actually, if you just search on the Google, or if you just have news, if you are reading the news, if you are having the eye on the social media, then you will get to know all these things. Actually, this is a very famous case, and you may be knowing about that. It's a Sholay versus Ram Gopal Verma ke Sholay. So as that this is actually the title, but again they have filed the infringement case in the court, and they have to change to it the Ram Gopal Verma Ki Aag. So they have changed the name of the movie to Ram Gopal Verma Ki Aag, because the producer of the Sholay film, they have raised the issue, and they have filed the infringement case against this. That's why they have to change the name. And again, you can just see in the last part that they have to pay this much amount as a damage. Then this is another case. It's a tips industry versus Wang. So this is the case related in the music industry. So Indian music streaming service. So this is actually owned by the Airtel. And whatever the recordings, actually they are labeled with the tips, but they have put it on their website. So this they actually tried in the court very hard by just under this section 31D and all these things, but at last this High Court rejected this argument, and just held that they have to actually whatever available to only radio and television broadcast as the text of the provision suggested. So they have to remove all these things from their website. This is the another case study. Then this is the another interesting case, I can say. It's a Patanjali versus Google. So again, this Patanjali Ayurved Limited and Baba Ramdev, they have actually filed a case in the Delhi court that the material of this Patanjali is put up on the YouTube. So they filed the case against the Google, and they fought for that. And then High Court gives the decision that whatever material they have put on the Google and also on the Facebook, they have to remove it, because that is it's a violation of the law, it's a violation of the act. So they have to actually remove the material related to this Patanjali from the YouTube and from the Facebook also. Then this is I have given purposefully the title of the slide as a war, because it's a really war, because yesterday we have talked about the patents, and I have mentioned that each and every part of the mobile, it is patented. So starting from the sensors, camera, touch screen, the technology used for it, till the processor, all the things are patented. So the processor and also the OS, that is operating systems. It may be Android, it may be Macintosh. All these operating systems all also patented, and it is the rights are with the company. So if you just see the few points which are mentioned on the PPT. So in 2010, Apple and Samsung, Apple sued the Samsung, filed the infringement case against the Samsung. Google had to step in because it is related with the mobile application distribution agreement. Then Google law revealed that the company agreed to provide full or maybe partially related to the 4 patents. So it's just a war between the big mobile companies actually. So you can just read the contents from the just I have mentioned few points. Actually, it's a very big cases and they are very big case studies. So Motorola accused Apple of infringing several patents, which included how cell phones operated on 3G networks. So they have filed the case. Then on the other hand, Apple claimed that Motorola violated its patent to certain smartphone features. So some of the features they have stolen. So like that, then again the copyright case was this actually was started and it was remain in the court for many years, and then this was dismissed in the 2012 because Google acquired Motorola, and on the grounds that there are no sufficient evidence, they just dismissed the case. But actually the court, if you just go through the case studies of all these mobile phone companies, so this frustrated judges have thrown the Apple and Motorola out of the courts 3 times, telling them to solve their problem between themselves. So there are many infringement cases filed by the famous mobile companies in the court, and they are fighting to each other. Then in 2014, actually, they have actually decided that Apple and Google, they realize a joint statement and they agree that we will settle all these issues related with the patent and copyright also, and they will work together in some areas of the patent reform. So it is very vast, and if you just go through the case studies of these mobile companies, then you will understand that there is a fight between very big mobile companies, IT companies also, and they have to prove in the court cases also. Otherwise, they will not get the protection of their work. That is very important. So this is about the few cases. And just to sum up with the Copyright Act and its registration, and based on the few cases and challenges of the Act, I can say that it is always a critical issue for the creator, because it is very difficult actually to prove that this particular work belongs to me. If you have filed a copyright registration form, and if you have got the copyright of the material, then also, if suppose you have filed a infringement case against a particular person and he just proved that it was done intentionally, it is under the fair use clause, then you cannot do anything. So it is very critical issue for the creator to protect his work. But again, because of advancement in the technology, now everything is available freely, and they have actually amended the Act now, and they are trying to actually amend the Act and include all the things which are now related to the digital world. So there are various issues related to the copyright, and some of the issues have actually solutions. So plagiarism can be resolved in the court, and plagiarism does not actually stand if you have mentioned the reference. So usually we give the reference of the author of the or research paper. If you have written down the suppose literature survey chapter in your PhD thesis, then usually we give the reference. So that is not under the then copyright infringement. So details of the ownership should be mentioned in the contract. Then website content stealing can be resolved in the court. Then Creative Commons can be protection through licensing. Then issues related to the academic writing is also can be sought out, and if you have given the reference, then it is not the infringement. Then according to the Indian law, registration is not the prerequisite. So I have in the initial state only, I have told you that if you have written or if you have created some work, then by default the rights goes to you, automatically it is given to the creator. But if you have to file an infringement case against somebody, then that should be registered properly. Then only you can prove that the work belongs to you. So that is the another thing related to this Copyright Act. So this all about is related to the Copyright Act and the challenges of the act and the registration process and all these things. So yesterday some of the participants actually requested that they want the important links. So I have mentioned here, and I will give this to the Ameya sir also, so he can put this in the group also. So these are the important links, and this is the actually one of the article I have written, so you can go through the article of also. So this is all about the Copyright Act and the challenges to the act. So thank you so much for your patient listening. Now I would like to happy to answer the questions if you have any questions. Yeah, just a minute. Yeah, so if you have any questions, I would like to take. Yes. Just a minute. Just a minute. One of the questions in the chat box. It is related to, is it possible to get copyright for my YouTube video? Yes, it is obviously with you. You have published your video on the YouTube, then actually the what I can say, distribution or communication rights are with YouTube, but the content rights are with the creator or owner. So it is with you by default. Any other question? Copyright of Rangoli. Okay, so this actually we have to check that whether it comes under the, it is actually coming under the artistic work, but then again, see, similar to the patent, you have to prove that if you want to take a copyright of a Rangoli, then you have to prove that it's novel, it is useful, and all these three conditions that you have to prove. Then only you will get the copyright of the Rangoli. Yeah, Rangoli you can get, but again you have to prove that it is not previously available publicly. It is totally new novel. So if conditions are satisfied, then you can get definitely the copyright of Rangoli, because it's a very common thing. Yeah. So yeah, one of the questions from the faculty member, I think. Just a minute. The copyright related to research article, paper, review paper, etc. Yes, I can explain this. See, we faculty members and students also, we write the research paper, article, and we send this article and paper to some of the journal, maybe international, national journal, or maybe in the, we present it in the conference, and then it is published in the proceedings of the conference. Then, as I said, whatever material paper you have written, the copyright of that by default goes to you. But again, see, when you are suppose publishing this, your research paper in one of the maybe UGC listed international journal, then if you just see carefully, they just send you a one form, and you have to fill that form, and in the form it is mentioned that the copyright or maybe the rights of that material goes to that journal owner. Okay, though the rights of the material or the paper that you have written are with you by default, but if you have published in one of the international journal, then that right goes to that journal. Is it, am I clear? Because see, the one one of the things, please remember that if it is similar to the employee and employer, isn't it? So if being an employee, if you have created or done something, then the rights goes to employer. It is same thing. If you have published a research paper in any international national journals, then they give you the form that the further distribution communication rights are with the journal, though the rights of the material is with you, but the distribution communication or the further rights are with the journal. Just a minute, it is something about some YouTubers are use small clippings from other videos. So how is this allowed? Why are not they sent? Yeah. So one of the thing I don't remember actually, but in the second session I have included this. Sampling is allowed. Sampling means what actually? Sampling is nothing but part of the maybe it's a music or maybe a song or maybe a clip that is allowed. Okay, so if you are using some of the part, only the thing is that you have to take the permission of that owner. Okay, if you have taken the permission of the owner, then it is actually allowed, because according to the act, sampling is allowed. Sampling is nothing but it's a sum of the part you have taken out and you have used it for your purpose. So that's why this some of the YouTubers use small clippings for their videos, but again they have to actually take permission of the owner. They can actually file the infringement case again against you if you are using it. Any other question? If anybody has raised the hand, you can just go unmute yourself and you can ask the question. Anybody wants to ask any questions? Yeah, I have already explained this plagiarism. So plagiarism, how you can actually avoid this? If you have mentioned its reference, it's quite sufficient. And as a teachers, faculty members, we usually use this. Yeah. Any other question? Yeah. So what is the benefit of copyright? Can we get any financial benefit from it? I will just a minute. I will give you one example. See, now we are observing the TV shows, dance shows, isn't it? On the TV, many producer they have launched a show, Dance India, or maybe the other show related to dance. So the songs which are they using, they have taken the permission, and the further thing, some of the part of the financial amount they have to give to that company. So for each and every song that is used for a commercial purpose, you have to pay for it. Because when you are using the song for a particular show, then it's for the use of, it's a commercial use, isn't it? So you have to pay to that company. So there is a financial benefit. Am I clear? If you're using it for the commercial use, then you have to pay. So whatever now shows we are observing on the TV, it may be somebody is singing some song. Then also, if it is for the commercial use, then whatever the company have the sound recording, maybe the rights of that, then you the show producer of that show has to pay to that company. Yes, if you are using the images from Google and if you are giving the its reference, then it is allowed. Yeah. So see, precautions to be taken while preparing a personal YouTube channel. So actually, it is very you should be very careful because recently I have heard one case that one of the college, I think they have now from last 2 years we are conducting the programs online, isn't it? So it was a formal program, and it was started with the Vidyapit Git. It was happened in the Pune, so it was started with the Vidyapit Git and ended with the Vande Mataram. But the Vande Mataram, the whatever is the they have used what I can say, the Vande Mataram original work, or maybe whatever the singer has sang that Vande Mataram. So they have taken the objection, and then YouTube actually took the objection on that. So you should be very careful while putting anything on the your YouTube channel. The contents, the PPT which you are putting on the YouTube, that is also you should take care about it, because if anybody find that you have used the material of that particular creator, then he can file the case against you. Yeah, so just a minute. There is a big being a teacher, if we scan material from textbook, explain that material for students, upload that video on YouTube and share a link publicly, is it allowed? Yeah, if you're doing it for the for your class, it is allowed. I have mentioned this, that according to the act, if you are using it for your class, then you can use it, and it is allowed. Suppose I write some article, and can I use this symbol, that is copyright symbol. So see, you can actually, as I said, by default copyright is with you, with the author. So you can use this symbol, but registration is required in that case. For logo, you should go for the trademark. Slogan, actually, according to the Copyright Act, you cannot have the copyright of slogan. So slogan is not in the era of the Copyright Act actually. Logo or sign, you can have trademark of logo or sign. Yeah, through licensing, actually, you can enjoy the financial benefit, because see, suppose I have written a book on the maybe Patent or Copyright Act, okay, in my language, whatever I have understood, and if I don't have sufficient amount to print it, just a minute. So, you don't have sufficient amount to print their copies, then you can have the licensee for that. You can go to the production company, and again, then you have to prepare a written agreement, obviously, and on the basis of that, maybe 60, 70, 80% you can have the financial benefit of that. Yes, obviously, licensing, through licensing, you can have the financial benefit. Any other question, or shall I go ahead? Okay. Okay. The last part of the this workshop, I just wanted to share you. Just a minute. Give me a second. I will share my screen. Is it visible to all of you? Is it visible? Okay, okay, fine. Thank you. Yeah. Just a minute. Yeah. So the half of this last session is for the faculty members, half of the session is for the students. So the role of this IPR in the academics, incubation, startup, and career opportunities in IPR. So as this is a university, and yesterday also Srivastava madam and Tanwar madam, they are actually heading the very important cell, innovation cell, then incubation cell, and also entrepreneur cell. So you know about all these things, but from the point of view of students also and faculty members, I have added this in the last session. So basically, three types of intellectual property rights are important for us, being an academician or being a researcher or being a faculty member. So these three are important: patent, copyright, and industrial designs. So for because see, all the faculty members who have joined the session, they are from the different branches. Some of them are from the science and technology, some of them from art, some of them from commerce and management. So this is actually, if you just see, then for science and technology, most of the things, they are related with the inventions, ideas, process, so all these things. So mainly for science and technology branch, patent and industrial designs, they are useful. Then for arts and humanities, obviously they are related with the articles and artistic form, so it is related with the copyright. And for commerce and management, all three four are important: copyright, then maybe industrial design, maybe trademark, or maybe the patent. So all these things are important, and I have just given as a what I can say, brief idea about this, but all the IP are related with all the branches of our education field actually. So IPR and collaborative research. So as this is a university and you are working in the university departments, and most of the faculty members I can see in the audience list, they are doctorate and they have actually done the research. So it may be the repetition for them, but I will just wanted to highlight these points. That's why I have included this in the this last session. So collaborative research, we already know that through this collaborative research, we can do any, just a minute. Yeah. So IPR laws can impact international research collaboration. So we can, being a university actually and departments, you can have the collaborative research at national level, at international levels. And through this research, whatever is the outcome, you can go for patenting this research, this outcome. So that is the one of the important thing, as it's a university. So researcher can also consider engaging with such company to manage the IPR. So there are many companies who can manage this IPR. Being a university also, you can actually, you have done this because being a university, you have separate innovation in your incubation center and entrepreneurship cell also. So these are just a few funded research projects. These are the agencies which can give you the research projects. So DST, UGC, ISRO, CSR, there, it's a very long list. I have just included few names here. Then role of IPR in research. So basically we all know that being the faculty member also, and being a student also, because most of the students may be from the PG, post-graduation. So whenever you have any idea, or then you will convert that idea into the concept, then concept to project, then project. To do project, you will require funds. Then for, in that case, you will find out just funding agency, and then you will complete the project, and whatever is the outcome of that project, either there are 3-4 ways actually. You can publish it, or you can have a patent, or you can go for the copyright of that. So there are actually 2 ways as a researcher we can go. Either we can publish your work, or either you can go for the patent. Now why this or is there? You can just see here, it's not and. Why or is there? Because if you are going for the publication, then you cannot have patent. Why it is so? Because if you just remember in yesterday's session, now for publication, let me finish this first. In UGC listed journal, you can publish, in scientific journal, in national international proceedings, conference proceedings, or maybe you can have the article publication in any newspaper or any other way. You can file this patent application in IP India office. Yesterday we have talked about this. Okay, so why this I was talking about, why if you go for publishing you cannot go for patenting, if you go for patenting you cannot go for publishing. So why it is or and not and? Because the main condition for filing the patent application is that the work should not be publicly available previously. So if you have published something related to your research work previously, then you cannot have its patent. Okay, and if you have, suppose some of the researcher they usually they just put the what I can say, not exact outcome of the research in the paper but just outline of that work, then in that case it is allowed actually. But just a minute. Okay. Yeah.
You mean to
So
say, excuse me, ma'am.
yeah.
You mean to say if somebody has gone for a white paper that is preprint of publication, then in that case they can go for this?
No, actually, if you have given all the details in the white paper or maybe in the research article, then it is considered as a prior art. The meaning of the prior art means previously publication article. In that case, it is not allowed. If you have given all the details of your invention. But if suppose you have mentioned the just what I can say, work line of the invention and what you have done in the invention, if roughly if you have mentioned, then you can go for patenting. Am I clear?
Yeah. So you mean to say that patent is more important? It's having more weightage as compared to that of a patent publication.
Yeah. See, no. Granting a patent is very, very important rather than publishing. Because if the patent is granted to you, then through licensing, you can have the financial benefit of it, isn't it? But if you have publicized that content through your research paper, then it is publicly available. You don't have benefit of that work with you, isn't it? So nowadays, actually, just I remember from that publication word. So now what researchers are doing, if you just see the process of registration of this patent, then in the third step, it's a publication. Publication means what? You have filed a patent application in the IP India office. Okay, they have scrutinized your application. Okay, and then that application is made available publicly for raising any objection on IP India site. Okay, so what usually nowadays I just see this in LinkedIn profiles and also in the newspaper that researchers are just stopping their work, or they are just quite satisfied by publication of their research on IP India site. So they are just stopping the process of registration on this third step. They are not requesting for the examination, the fourth step of your patent registration process, and they are just happy with the publication in IP journal. But it is not sufficient actually, because to get a grant of the patent is important compared with the publication of your work on IP India site. But to get a credit, that they just say that it is published on IP India site, and they are happy with that. Is it clear to you?
Yeah, thank you, ma'am. Thank you.
Yeah. Okay, so this is another actually whether to go for the publishing the work or for patenting. So again, this is another thing. Just now you asked this question actually. So what is the main thing is that first of all, you can check the patentability of your invention. That is the first step, and it's a not only first step, it's the initial step, I can say. And yesterday I have talked about this patent search, and I have shown you the sites also. So just to check whether your work is eligible for patenting, means whether it can be patented or not, that you can check. Because how you can check? Because if it is a similar kind of work or invention is previously patented, then you cannot go for it. Okay, so You can go for the patent search in that case. And the third point is also important. Discussing an invention in public is known as a public disclosure. And that's why publishing a research paper based on the invention will also be treated as a disclosure. So if you have disclosed your invention publicly, then you cannot go for patenting. Okay. So you can confirm this whether your work is patentable or no. That you can this is the same slide I have shown in the yesterday's session. So all these sites are free. So Google Patent, Esplanade, Patent Scope, then USPTO, then Lens. All these are the free sites. You can just search on the site whether your work is new or previously patented. Then from this database you can search. These are the paid sites also, that all the things yesterday we have seen actually. But researcher actually should go for filing the patent application, and they should not actually happy with the publication of their work on the IP in India site or in IP journal. They should go for the granting a patent. So further steps in the procedure they should follow. So this procedure also, just a minute. Just a minute. Yeah, just a minute. I have skipped one slide actually. Yeah. So I was talking about this. The publication in IP journal is not sufficient. Granting a patent to research or inventor is important. So you should go for the patenting. So then another type related to us being a faculty member is the copyright. So you can have the copyright of your work. So this process just now I have in the first session I have discussed. This is the format of the application that is also discussed in the first session of this day. This I have not discussed. So we will see this industrial design registration process. So if you remember in the first session yesterday, I have talked about this when I have explained the types of the IPR. So industrial design is nothing but it's a 2D or a 3D design. So you can have the rights of your design under Industrial Design Act 1911, and the process, I will just go to the pictorial form of it. Just a minute. Just a minute. So I have included a concise format. The net is quite slow. Just yeah. You can see this now.
Visible.
Just a minute.
Hello. Yes, it is visible, ma'am.
Okay. So first step, actually, if you just see the registration process of all the IP, then they are more or less similar. First, you have to file the application, then formality check done by the government office. Then it will go to the examination. Examiner will check all the things. In case of patent, it will check 3 conditions, that is useful, then novel, non-obvious. These 3 conditions are checked for the copyright also. Then it is publicly available. Anybody can raise objection. If objections are raised, then applicant has to satisfy that objection. If it is satisfied, then it is accepted, and then it will go for the further details. So if you just see the procedure is the same, okay, then it is publication in official journal, and then certificate of the design is issued to the applicant. And if any objection is raised, and if applicant doesn't respond within 6 months or doesn't fulfill that questions, then that application is actually refused by the government office. So the process is same. The term of this design is once registered, it's a 10 years, and you can renew it for the 5 years. 5 years. Again, renewal is compulsory. Yesterday, one of the faculty member, I think they have asked related to management, commerce and management. So yes, a business method patent, actually being a faculty member or researcher of the commerce or management field, business method patents are allowed nowadays. They have included this. So this business method patents are a class of a patent which disclose and claim new methods of doing business. So this is one of the kind, or you can say method for the commerce and management researcher. They can go for having the patent of this business method patents. Okay. So this includes new type of e-commerce, insurance, banking, and tax compliances. And this is actually relatively new species of a patent, and they have to include this in the act. There have been several reviews of investigation of the appropriateness of this actually patenting a business method, because previously it was with only process and product. And from this you can understand why they have started they have included this, because the high profile court cases, because nowadays everything we are doing online, isn't it? So through Amazon, Flipkart, and everything is online. From last 2 years, the usage increased so much. So this Amazon patent on its one-click shopping process and Priceline patent. So this is actually the court case. And then they have realized that, yes, this business method actually should be patented if it is new again, isn't it? Because for patent, again, these three conditions should be fulfilled: new, non-obvious, and useful. So in law, there is a 4-part test for patentability of a business method. As there is any invention similar to invention, so the way of doing business has to be useful. As I said, it has to be new, and also it can't be so incremental that it would be obvious to a skilled practitioner. So these three conditions in the first session, I think second session, I have discussed when I have discussed the Patent Act. So all these three conditions means, suppose yesterday I think some of the participants have asked this question, that whether she has started some business and she wanted to take its patent and thing. So I have answered the question yesterday also, that if the method is new, then you can have the patent. But if you have just done minor modification in that, and if you're going for the patent, then it is not allowed. So incremental means just minor modification in the available process. If you have done, then it is not allowed according to the act. So this business method, you can have the patent of it if these three conditions are satisfied. So the patent office does not issue patents for old business method. It's quite obvious. If the old business method is simply made electronic, means if you have done, you have the old business method and you have just converted into the online method, then it is not allowed. If it is something new in the process, similar to this Amazon actually, it is initially when online shopping concept was introduced, then it is a new business method, and then in that case these big companies, they have already taken its patent. So this is related to the commerce and management. Then just in 10 minutes I will just brush up this, because it's a university and you already have this incubation, startup, and all these things. So incubation center is a main role is that it gives the support to the small enterprises or startups. This is the role, and you might be knowing about the role of this incubation center. It basically supports the ideas. Maybe students are in the audience, so if they have any ideas, they can just contact their teachers, and through this entrepreneurship cell, through this incubation center, they can convert their ideas into the startup, and they can start their own company also. So I have just included information of this. You can go through this actually in the on the Google also. So this is actually incubation center plays a vital role, and it's a source of funds, human power, and market potential. So the cell help the students actually to start with their own company. So there are many schemes actually, state government, central government schemes are there, and I have given the links here, but instead of going to the links, you can just go through the schemes. One of the I can click actually, but it will take time because of the internet connectivity, it may be stuck up in between. So you can go through all the information related to startup. It's a Startup India website is there, and each and everything related to startup is mentioned there. So the definition of the startup and all these things. So this Departmental of Industrial Policy and Promotion is very, very important. This is helping a lot to have the startup. This is the eligibility criteria to have the startups. This also information you can get on the startup site. So if you have any technology, or maybe product, or maybe business model, distribution model, methodology to solve the problem, so all these things you can just convert this idea, a few ideas into the startup. And what is the IPR role in the startup, that I am going to explain. Because if under this Startup India actually you are eligible to take the benefit such as 80% rebate of your patent fees. Means if you have a invention, and if you have taken a patent of this, and then if you have done registration for the startup, then you can get the 80% of the patent fee back. So this is also amended in the Patent Act in 2016. So these are the actually guidelines for the startup. Okay, I have actually given the link, but it is actually taking time to open up. Yeah, one of the file is open. Okay, so instead of that, actually, we'll continue because it is taking time actually. All the links of this I have included in the PPT, but because of net is little bit slow, so it is taking time. So yesterday also I had talked about this, that commercializing the patented product is very important, and through this incubation cell startups, you can commercialize your idea, your invention. So initiative taken related to this IPR. So government has now taken initiative regarding this, and this IPR actually National IPR Policy is included or introduced in 2016. And the aim or objective of this is this policy is nothing but to have the IPR awareness, generation of IPRs, then legal framework, administration, management, its commercialization. So government is taking a lot of efforts to spread the awareness of the IPR and commercializing of it. So everything is mentioned in the policy. So this policy is the CIPAM, and it was created for simplifying and streamlining the IP processes. So if you just see the scenario before maybe 2012 or maybe 11, then scenario is very different. And if you just compare it with the IP filing recently in 3-4 years, then it is totally different. So UGC also have taken the initiative regarding this, and intellectual property right is one of the credit subject is added in the CBCS pattern. Now UG undergraduation is also shifted to CBCS, so this is included. And then in National Institutional Ranking Framework, this is also included, and significant to research and professional practice. So particular marks are assigned to this. So both published and granted patents, they are assigned the particular marks. Then NAC, Yes, National Assessment and Accreditation Council, they have included this research component in the criteria 3 and allotted marks to it. So government has taken initiative in spreading the awareness of the IPR, in commercializing it, and in each and every aspect they are trying to actually give. And in last 2 years, in this pandemic situation, everybody understood the importance of this IPR, because when it is come to the vaccine for the COVID, then it is a different angle, and we have actually experienced that in the last 2 years. So just 2 minutes, a current scenario, just to have the information about this. So this WIPO statistical database. So you can just see, and the current position of India in this IP. That's why I have included this, that it's a statistical database. So in September 2018, 45,379 patent applications were filed, 12,387 were sanctioned, and this 29,789 were actually withdrawn. So just remember one thing, that if you are going for the patent, then these 3 conditions has to be fulfilled. One is the novel, non-obvious, and usefulness. So this 3,203 patents were rejected on the basis of these 3 conditions actually. So this is very important, because when examiner examining the patent application, on the basis of these 3 application is rejected. So this I have told you yesterday, that there is a highlighting tangible improvement in the IP ecosystem of India. So this is, you can just see here, 6% increase in patent, 15% increase in trademark, and in pharmaceutical sector, there is a vast increment in 2020 because of this pandemic situation. So globally, trademark filing is increasing, and this is the situation of India. So we are at the 8th rank in IP filing in 2020. So this is very recent data actually. So India ranks 40 out of 53 countries, and now it jumps to its innovation index jumped to 48 in 2020, and these are the actually in 2021 recently 28,000 patents were granted. So you can compare this with the 13-14 data, and you can just see the increase in IP filing in India. So India is improving day by day in filing IP and protecting their intellectual property rights, and it's a very good sign, because all the things or economy of the nation basically depends upon the intellectual property and its IPR. So as the innovation index is increasing, we are improving day by day, what I can say, and it's a very good sign for being an Indian. So career opportunities in IPR. So this is the last part of the session, or last part of the national workshop, as many students have joined the session. I just would like to highlight that there are many career opportunities in IPR. Actually, in big companies, or in maybe medium scale companies, there is a separate IP cell who will take care of the intellectual property of the company. So you are having the career opportunities in IP cell, in the private sector, in the corporate offices, in R&D centers. So patent docketing officer, the patent paralegal, patent manager, patent agent. So if you are a science graduate, so science graduate is only the eligibility criteria. You can just go for patent agent exam, and you can, if you just clear the exam, you will be official patent agent. You can register in the IP office, and then you will be registered patent agent, and you can file the patent of any company, any person in that case. Then patent examiner, patent searching. See, these two are very vast topic, as I already mentioned, that patent searching means if your invention is previously patented or no, you have to search previous patent, and there are million patents available or already filed. So searching is very critical, complex, and vast. So this is another field you can go through this IPR. Then these are the roles and responsibilities if you are going for the intellectual property or maybe IP cells of the company. So these are the identification, patenting, licensing, marketing, reporting, all these things comes under this. You have to manage all these things being a member of IP cell of the company. So these are the career opportunities. And if you're a lawyer, maybe then you can go for filing the copyright application, then patent application. So if you are lawyer, it is allowed. If you are just a science graduate, then you can go for the patent agent examination. If you clear the examination, then you have the rights to file the patent application in IP India side. So coming to the last part of this, that is the concluding remarks. So we have discussed from 2 days, we have discussed each and everything. I will not say each and everything, but most of the things I have tried to discuss in this 4 sessions. So we have discussed about the types, its importance, then how you can commercialize the patent, then how improvement in basic and applied research is required through maybe collaborative research or through funded projects. And then being a faculty member, being a student, it is very important to continue with the research work, to continue with the invention, with the novel ideas, and not only keeping this invention, novel ideas with you, but go for patenting it, take copyright of it, and then only do not stop there, go for commercializing it. So it is very important to file any IP, intellectual property. And in the last part, I have discussed just a career opportunity in a very brief manner. But remember that in IT companies, in big companies, they have separate IP cells. And nowadays, many peoples are actually required in this IP cell. So thank you so much for your patient listening from last 2 days. I'm just talking and discussing about the IPR, and patiently you are listening. So thank you so much. Thank you, Tanvar madam, Ameya sir, and VC sir, Tankeshwar sir. So giving me the opportunity to share my knowledge with you all. And I'm also happy that lots of participants, they have raised their questions to me, and most of the questions I think I have answered, but still I'm happy to have more questions if you have. Thank you so much.
Thank you, Jayashree ma'am. Thanks a lot for such an informative session, and in fact everybody would have enjoyed it a lot, and there was a lot of scope and room for everybody to understand the basic concepts of patent, copywriting, and how to proceed for that, and what is the important and the career aspects. And one of the things which is really appreciable, that you try to connect it with the startup also, so that the students who have joined from entrepreneurship cell and incubation and innovation will try their level best to take the benefit out of it. So now I'd like to request Dr. Nishant Singh for a formal vote of thanks. Nishant sir?
Can we have just 1 or 2 questions if anybody has?
Definitely.
Because in the chat box, I can see 1 question. Yeah. So research scholar from commerce and management, if the model is already present, but we are the first person to find the relation between, as well as first time verifying, as well as measuring, and take patent or copyright. Yes. Business model, I have talked about this business model. The model is already present, you are saying. Okay. So, but we are the first person to find the relationship between the, okay. So see, if you have done some modification in the existing model, then you have to check actually, because if it is just a minor modification, then it is not allowed, but you can check it and you can go for the patenting it for the business method. Okay, if it is a business model actually. So you can think about its registration, but before that, check again these 3 conditions: novel, that is new, non-obvious, and useful. So if 3 conditions are satisfied, then you can definitely get its patent. All the best. So if you have any questions, yeah.
Ameya sir, can you please unmute Nishant sir?
Yes, ma'am. I have unmuted him.
Yes, ma'am. Now unmute, ma'am.
Yeah. Thank you.
Thank you so much, Sunita, ma'am. Good afternoon to all. It is a great honor and privilege to propose the vote of thanks on his memorable workshop. First and foremost, we are grateful to our Chief Patron, Honorable Vice Chancellor, Professor Tankeshwar Kumarji, Central University of Haryana, for his words of encouragement. His able guidance has always encouraged us. I thank him for his vision, his interest, his always open and continued unconditional support. I thank our resource person, Dr. Jayashri A. Bengali, trainer, SkillSlate Foundation, head electronics department, Kaveri College, Pune, who despite her busy schedule has take out time to grace this occasion. Dr. Jayashri for enlightening us with their knowledge. Today's workshop was full of knowledgeable and informative things about IPR, patent, and copyright. I thank our well-wisher, Professor Sunita Srivastava, workshop convener Center for Innovation and Incubation, Central University of Haryana, for her stewardship, support, vision, and commitment. Thank you, ma'am, for guiding in all aspects for this workshop. I thank Professor Sunita Tawar, our ESL coordinator and workshop coordinator, for their unstinted support for this workshop, guidance, and help. I would like to thank Mr. Ameya Agrawal, workshop organizing secretary and social entrepreneur and founder, SkillSlate Foundation and Zovy Studios, for help us in all aspects of this workshop. I heartfully thank all the ESL department in charge, head of various departments, and the faculty for their valuable contribution, guidance, and encouragement in all our efforts. I thank all the distinguished invitees present here, accepting our invitation. I thank the member of the media for evincing interest in covering the event and all good hearts who worked behind the screen. Last but not least, I thankful to all the participants who have joined from north to south point of the country to make this workshop it a grand success, without whose support it can never be possible to make such knowledgeable event. Once again, I thank you all for your attention. Thank you so much. Thank you so much, ma'am.
Thank you, Dr. Nishan. In fact, I'm very thankful to all of you, including SkillSlate organization and NGO, which is always there to support us for all type of good causes. And I'm really thankful to Mr. Ameya Agrawal, who always open-heartedly welcome us for all sort of collaborations for educative and informative sessions, and his team. So thanks a lot to Dr. Ameya, SkillSlate NGO, and Dr. Nishan, and all and one presentee here, including a resource person who is actually very informative, and under her guidance, definitely in the next time when we'll interact, I'll show her that this much number of students have turned up with their patent or copyright or some other thing like. So I'm very thankful to all the team and all in one presentee here. Ameya sir, now it's up to you.
Thank you so much, ma'am. Thanks a lot. It has always been a pleasure working with Central University of Haryana, and the number of participants has proved us that when two organizations with same vision of maintaining a skill development and towards the common goal, then people do support that particular initiative. And I'm really glad for all the participants who have joined us today. And I would like to request you all that today, if you are not shy enough as yesterday, you may please unmute yourself and share your feedback. We do want everyone to open up, because this is also one of the skills. Often it is easier to talk in person, but when we started, we realized that people have this Zoom phobia or fear of talking on a Zoom call or a virtual call or talking on a camera. They call it a camera phobia. So this is also a skill. So I request you all to take this opportunity to conquer over that skill and feel free to feel comfortable to share your feedback with us all. So if you would like, please unmute yourself and you can share your feedback with us all. Anyone would like to share their feedback, please unmute.
Yeah, hello, sir. Good afternoon. This is Pushpalata from Bangalore, and quite informative session. And thank you so much, Jayashree ma'am, for clearing my doubt, because this was the thing which it was running from day one, and I got the information. Thank you so much for the informative session.
Thank you so much, ma'am. Thank you so much. Thanks for starting the feedback loop. I hope more people will follow and will share their feedback. In the meantime, please feel free to share your feedback. I would also like to share with you all that we are planning a big program on entrepreneurship, and international level program on entrepreneurship, along with the very Central University of Haryana and Dr. Sunita Tanwar ma'am, and the details will be shared shortly with you all. So I request you all कि अगले महीने में आप आपकी dates बचा के रखिए, because it will be going to be a great and a huge session. We will be calling the industry experts, the mammoths, I would say, in the field of entrepreneurship and this particular domain. And I'm sure that you guys will be learning a lot from that session. If Sunita ma'am permits, I would like to request her to share a short idea with the participants, what is in plan. Otherwise, we can keep it a secret and can make a big announcement later as well.
No, thank you, sir. Thank you. In fact, definitely, I would like to take some time. Thanks a lot to reminding me to announce things here. Definitely in coming time, we are going to have a very big international conference that is on innovation and entrepreneurship, with so many other events clubbed together with SkillSlate organization, which is always very sincere for these type of activities. And I would like to share it here only that how we have gone for collaboration. It is because of one of the international conference organized by SkillSlate organization under Mr. Ameya Agrawal. That was on assessment criteria and all. And while going through that very conference, I'm very fascinated with the way the things were organized. And having same sort of view, I think it would be wonderful if both of the organizations club together, collaborate for these sort of events. It's beneficial. It's a win-win situation for both the organization. And other than this, I just want to say that in the next week, that is from 14th of March, Central University of Haryana is going to organize one of the GYAN program. GYAN is, that is Global Initiative for Academic Network, sponsored from MHRD, which is a 2-credit course. In fact, student of any university can opt for that course and they can exchange their credits. And that course is wonderful in the sense that you'll get an foreign exposure also. There's an expert on entrepreneurship from foreign, and the course is jointly done by De Soto University, Spain, and that of Central University of Haryana. I being the coordinator of that program, I want that most of you people will participate in being a member of that course. It's a 15 days course, 2 hours each from 4 to 6 p.m. in the evening. All details you can find on Central University of Haryana website. You can have it from Ameya sir. It could be shared on the group also. And I want that all of you will be linked with us for all these sort of good programs so that we can serve you better. And in fact, in the feedback today, we'll welcome your ideas also for future workshops, future seminars, conference and all. Leave to Ameya sir.
Thank you so much, ma'am. Thank you so much. And I'm sure that we are going to receive a great number of participation from these people. I think people are still not comfortable sharing the feedbacks online, but I hope, I think we should organize this skill development workshop or soft skills program for the people as well, on how to be comfortable on camera, how to be comfortable talking to other people, and how to be comfortable networking with the other people. Because in this period, this is actually a skill which is required, because everything is moving online. So you need to feel comfortable while talking to other people, talking to new people. So I'm not sure why many of you have not taken this opportunity, because in our other programs, many participants are always eager to talk to the speakers, to talk to the organizers, and share about their what they do, how they like the program, etc. and stuff. But it's fine. No worries. We will have such programs as well, where we can help you make comfortable in all these kind of things as well. And again, I like to thank everyone and make a small announcement on behalf of SkillSlate and Kaveri College. On 8th of March, it is International Women's Day. So we are organizing an international conference on women and challenging barriers. There will be 4 vice chancellors from GH Raisoni Institute. One is from Saito University, Malaysia, University of Lingaya, and the president of Maharashtra Chambers of Commerce will also be joining there. And one special guest is going to be there. She's a lady, and she has traveled 4,700 kilometers on bicycle from Kanyakumari to Leh at the age of 56. So she's also going to be there. So I request you all that I have shared the registration links in the group. I will be sharing those links in the group. So do join that session, because as you can see, women, it is a very important topic about breaking the barriers for the women and making things accessible to them. And that is one of our motive at SkillSlate, to make opportunities and skills accessible to all. Because while we work in this sector, we realize that women do have a lot of potential. As you can see, many of our programs has women as a resource person. But unfortunately, we don't see that many women on higher positions, or that many women across various sectors. And I'm really glad when I came to know while talking to Sunita Tanwar ma'am about Central University of Haryana, when she briefed me, I was really glad that some of the key positions, like the convener of entrepreneurship cell, incubation center, all these are women. And actually we do need women in these kind of sectors as well, which is innovative, which is related to entrepreneurship. Because as you know, entrepreneurship opens a lot many opportunities, and a woman perspective is always some kind of different perspective. They take everyone along with them. So it is very important to have these have women actually at these kind of sectors, in these kind of fields, and that too on the top position, to make sure that you do attend that international level conference. Actually, this is not a national level, it is an international level conference, and it will be happening on 8th March from 10:30 a.m. on the Zoom and the YouTube platform. Again, thank you so much. If you have any last 1 or 2 questions, we do have 3 minutes left for today's session. Otherwise, I again thank you, Central University of Haryana, for this wonderful association. Honorable Vice Chancellor Tankeshwar Kumarji, Srivastava ma'am, Nishant sir, Sunita Tanwar ma'am, especially because she has been a great. When you realize, when you work with people, a positive energy connects, and you don't need to meet them personally or physically. You just connect over the phone, or you just connect over the Zoom platform, and that energy get transferred across. And Sunita Tanwar ma'am do have that vision about taking entrepreneurship and incubation ahead, and not only for just the Central University of Haryana, but also for all the people. And at SkillSlate, we are glad to connect with the esteemed Central University to bring these kind of activities for you as well. And I'm really glad that many colleges and organizations across India are joining SkillSlate in its mission, the mission of our non-profit organization, to make these skills accessible to all. And I do invite, if any of you are principals or vice principals, HODs who are attending these programs, if you would like to connect with us, please do drop me a message on, and we will discuss how we can take this forward. Thank you so much. Nagalakshmi ma'am is saying, ma'am, we operate all over India. We operate online, so it's not a problem. We have conducted programs for colleges in Telangana as well. Thank you so much. So thank you so much, guys.
Thank you
Today's
so much,
feedback
sir,
link will be shared.
for
Yes,
all the
Sanjana, do you want to
informative
share
session.
something?
Excuse me, sir.
Yes, Sanjana.
Good afternoon to all the respective members and the respective speaker person. I really want to appreciate all of your efforts about the wonderful opportunities you are opening up for us. And thanks for the wonderful sessions of ma'am. She really explained so beautifully and understandable way. And I really want to congratulate for the wonderful sessions that you have been doing all these days. Thank you so much, sir.
Thank you so much, Sanjana. I'm really glad that you came forward to share your views. Thanks a lot. Thank you so much.
In fact, Ameya Agrawal, sir, it would be, we need to thank Jayashree ma'am a lot because she has beautifully planned the sessions with the examples, with cases, and it's beneficial to almost all categories of participants, from student to freelancer to that of faculty members. And it's really wonderful, and she has a depth of knowledge in that subject. And definitely, I would like to be in connect with her in future coming workshops too. So a lot of thanks to ma'am for this these type of informative sessions. Thank you.
Yeah, thank you so
Actually,
much.
ma'am, we should be thankful, rightfully thankful to Jayashree ma'am. She has been very busy nowadays. And as I said, thanks to her expertise, she has been one of the most in-demand trainers across India. And I think all her schedules are blocked by now. So thank you really, Jayashree ma'am, for sharing your great expertise with everyone. Thank you so much. And thank you guys. We won't take much of your Sunday. You still have many hours to go and enjoy this beautiful weekend. Please go ahead. You can leave this meeting. The feedback link will be shared on the WhatsApp group, and the certificates will be sent after 3 to 4 days on the email you used to register for the certificates. All right. Thank you so much. Take care, guys. All the participants from the YouTube, thank you so much for joining. It has been a great pleasure to have you all as well. Thank you so much.
Thank you, sir. Thank you.
Thank you, sir. Thank you so much.
Thank you, Rakesh Kumarji. Thank you so much. Okay, so from YouTube also, we have got great feedback. YouTube people are also very happy. A few questions. Jayashree ma'am is there. Hello, Jayashree ma'am. I think she left already. No worries. I just wanted to share my screen on the YouTube. The screen on YouTube also looks very well. All the participants are very happy. So congratulations, Sunita Tanwar ma'am. Congratulations, Central University of Haryana. And congratulations, all the participants and who are associated with this workshop. Thank you so much.
It's a joint event. So congratulations to both of us, all of us, I must say.
Thank you, ma'am.
Yes, sir. Yes, sir. Congratulations, sir, again.
Hello, good day, guys. Everyone, bye-bye. Take care. See you again on 8th March and also on the workshop as ma'am said. Thank you so much. Thank you.